Outlaw Law is brought to you by Whitaker and Hamer, attorneys and counselors at law. Your law firm for life.
You're locked into the Outlaw Lawyers. Your hosts are Josh Whitaker and Joe Hamer, managing partners at Whitaker and Hamer Law Firm, practicing attorneys here in North Carolina. Offices in Raleigh, Garner, Clayton, Goldsboro, Fuquay-Varina, and Gastonia. I'm Morgan Patrick, consumer advocate. We get into legal topics each and every week, and you've probably got questions of your own. If you want to get in touch with the firm, get some answers, number to call, 800-659-1186. That's 800-659-1186. Leave your contact information, briefly what the call's about, and an attorney with Whitaker and Hamer will be in touch. And you can always email your questions to the show, questions@theoutlawlawyer.com. Guys, we've got questions. I love this part of the show, so let's get into it.
Well, Morgan, we got a couple of questions. The first one I want to tackle here at the firm, here at Whitaker and Hamer, we do a lot of estate planning for clients, and we do a lot of estate administration. So that's kind of two sides of the same coin. So we help people get their wills squared away, power of attorneys, kind of plan where their assets are going to go, trust, things like that. That's all estate planning. And then estate administration is once that client, we don't want any of our clients to pass away, but once that client passes away, a lot of times we'll handle the estate administration. So we take that plan they put in place for their assets when they passed away, and then we help execute that plan when that day comes. And so the first question we have this week is kind of an estate planning question, and I've kind of rephrased it. I always paraphrase these things to take out names and things like that. But here's how I'm going to phrase this question. So we've got a listener who said, I am remarried. I have kids with my first spouse. How do I make sure my kids and stepkids are all treated equally when I die? So in this fact pattern, attorneys always make things fact patterns. In this fact pattern, we have a client. I'm going to make him a guy. He was married. He had some kids. That didn't work out. It sounds like he's divorced, and he is remarried, and has we'll have stepkids. So he's got his new wife has some kids, and so they all live together. And so he's taking care of He's got an ex-spouse. He doesn't give us a number, but we'll say he's got two kids from a prior marriage, and then he's got his two stepkids. And I'm going to make another assumption in this fact pattern. We're using the term stepkids, stepchildren. So he has it adopted. These aren't his kids. He's not the father of these children. He's helping to take care of them. We're also going to assume he has not adopted these children. So these children are not his. The law is very clear on who your heirs are. If you don't do something, if you don't plan accordingly. And so, Joe, this is that blended. We call this a blended family estate plan, and these can be tricky.
They can be tricky, Josh. And you said one thing that really stuck with me early on when you were setting this up, and that's we don't want our clients to die. I think we can all agree. That that's the case. That should be the tagline for our firm. Right. We just roll out advertising. Mm-hmm. Whitaker and Hamer. We don't want you to die. But yeah, this is a tricky situation, Josh, and you said it. We've got what we would call, I guess, your biological blood children that you that were born of the first marriage. They are the kids, and then you get the remarriage, you get the stepkids, and this individual in this fact pattern could very much love these stepkids and treat the kids like they are his own children. But the amount of love he has in his heart for them and the way that he treats them, and no matter what he does, there's going to be a legal barrier in the event that he passes away, in the absence of some careful strategic estate planning.
Yeah, and that's the thing. I guess that's the situation to look at. So if he doesn't do anything, right? So if this gentleman, a valued listener and potential client of Whitaker Hamer, if he does nothing and passes away, and everyone survives him, so we'll make some more assumptions in our fact pattern here. So we always have to kill these guys off to make our fact pattern work. So something happens to him. The laws of North Carolina, it's called intestate succession. Since he does not have a will, has not put an estate plan together, the laws of intestate succession are going to determine where his assets go after his death. And And so here, let's say, I'm going to say he has 2 kids from a previous marriage, and he's got a current spouse, and that's who's going to inherit everything, right? The current spouse is going to technically inherit a decent chunk of his assets. The law is always wants to protect the widow, and of course his children will inherit percentages. So these are all percentages. These aren't specific assets. 2 kids and a wife, they're going to split everything, thirds, right? So if you have a house, everybody gets a third, right? That's not always easy to hand out to people, and so that's kind of the default. And in the default, these stepkids, stepchildren, would not receive anything, no matter how our deceased husband felt about them or cared for them. They're not his children, and the law is very, very clear about what happens in this case. So if he doesn't do anything, his stepkids will not receive anything in this situation. And so that's kind of the default. And so to prevent that, he would go to an attorney and he would set up an estate plan. And Joe, in that case, what do you think what would your advice to him be? Assuming he wants to take care of the stepchildren just like his own.
And that's it. That's the thing. The drawback to failing to have any kind of an estate plan in place, or having, an outdated estate plan that doesn't account for your current circumstances, because this guy could have an estate plan in place, but it could be, it's likely that's going to be something. Well, it's not likely. It's a certainty. If he's prepared an estate plan during the time that he was initially married, he's not going to have made any kind of arrangements for these stepkids that he doesn't even know are going to exist in the future. So, and you mentioned the fact that you can't have those specific, what we call specific bequests to individuals when, in the absence of a well-crafted estate plan, in the absence of a will stating otherwise. The statutes that dictate how your assets are going to be distributed, it's going to be very generalized. It's going to be percentages, and you just lose every aspect of control after your death if you fail to account for it. You don't put that into writing in the proper way. So, my recommendation, there's a lot of recommendations as far as you can keep it very, very simple, or you can make it far more complicated. But just as a very simple recommendation, the like baseline, what I would recommend is draft, either revise or draft an all new estate plan that accounts for these stepkids. And whether you craft a will that's going to leave them a percentage or some specific items that you would like them to have, or whether you wanted to create a trust that's going to establish a trustee that's going to operate for the benefit of those stepkids, you need to have some kind of concrete and tangible estate plan that's going to account for those stepkids. Otherwise, they're going to take nothing.
And I'm kind of taking this a step further than our question. In our fact pattern, we've killed off our loyal listener here, and we're looking at how his assets would be divvied up under the law. And then, of course, if you make a will, things are going to get divvied up however you want, within reason. There's some things you can't do, but if you draft a will, and you can do everything, you can do anything you want to. You can say, hey, I've taken care of my spouse, and she has assets in her name. I want all the kids to split certain things, or, I want stuff to go in a trust. I want to make sure their school's paid for. And your estate plan is wide open if you sit down with an attorney and you draft the relevant documents that you need to make your plan happen. If you don't do that and you die without that in place, then the state has a 7-page statute, and that statute is going to determine where things go, and there's not anything you can do about it once you're gone. But Joe, I would point out, we're killing off our listener. He's got a surviving spouse. Usually when we talk about estate plans, we usually craft it so that your surviving spouse doesn't really have to do anything, right? So you're creating this will saying, I want all my kids and my stepkids to share and share alike. But if we've done your estate plan properly, there's not really anything in your estate. So your will's kind of a catch-all. And so you may have to think about other ways to provide for your children, life insurance policies, setting up a trust that has real property in it, or some asset you want to make sure goes to them. Sometimes we have to create assets so that when you pass away, there are things in place for your kids since your surviving spouse. Usually you'll share some bank accounts. Your residence may be you and your current spouse, and so that'll just automatically go to your spouse. So there's a lot of things. Just when you die by operation of law, if you've set it up, your spouse is just going to keep on moving, right? So you may not even have a lot of estate assets if you're the first spouse to pass away. And so there's always some thought, like I said, life insurance or trust or something to create while you're alive that'll make sure your kids are taken care of when you pass away. So just something to keep in mind on that blended family discussion.
We got a lot of questions to go, guys, so we're going to get to it. You're listening to the Outlaw Lawyers, Josh Whitaker and Joe Hamer. You can find them at Whitaker and Hamer Law Firm. They're the managing partners there. They are practicing attorneys here in North Carolina. If you've got a legal situation you're facing, you've got questions, it can be about really anything, you can call this number, 800-659-1186. That's 800-659-1186, and just leave, a brief message, what it's about, contact information, and an attorney with Whitaker and Hamer will return your call. You can also email your questions to the show, questions@theoutlawlawyer.com. We're going to take a short break. We're back with more questions from our listeners right after this.